Hello, I'm Natasha Karamihou, and in this podcast, I will continue exploring inheritance rules under the Greek law. As we have already explained, the inheritance can arise either through a will or in the state, without a will. Let's start analyzing the inheritance through a will. How is it defined? The succession by will gives the testator the right to determine the person he or she wishes to inherit him or her, but at the same time obliges the testator to assign a part of the inherited property to certain relatives, such as the children or the spouse in life, who, even if they are not included in the will as heirs, are entitled to receive a percentage of the inheritance through the reserved share rule. The Civil Code provides for three types of wills: the private will, the public will, and the secret will. The private will is written in full by the testator's hand, dated and signed by him or her. A public will is drawn up by a declaration of the testator's last will and testament before a notary public with witnesses present. For the drawing up of the secret will, the testator shall, in the presence of witnesses, hand over to the notary public a document stating orally that this document contains his or her last will and testament. A renunciation of will action is also predicted and has to be made within 4 months since the declaration of the will by the court in this case. If no renunciation action has taken place within 4 months from the court declaration of the will, then the heirs are deemed to have made an implicit acceptance of the inheritance made to them through the will. In the case of a will, the declaration of acceptance of the inheritance, which is prepared by the notary public together with the preparation of the declaration for the payment of inheritance tax, must also follow. What specific actions need to be taken? Declaration of death of the deceased to the fiscal authorities. Deposit of the will at the court where the deceased's residence belongs, or where the residence of the person who possesses the will belongs. This is a lengthy procedure that can reach almost 300 days, namely a year, before a will is declared by the court. If the residence of the deceased is abroad, the declaration of the will take place at the consulate. If the heirs also wish to renounce the inheritance, they must notify the court accordingly. After the publication of the will from court, the preparation and payment of the inheritance tax is required at the fiscal authorities. After the signing of the acceptance contract, the heirs have to submit an ε9 tax document in which the inherited property will be listed. The inherited property needs to be lodged in κτηματολόγιο or υποθηκοφυλακείο if a real estate property is concerned. What we need to keep in mind is that the law regarding the declaration of will is about to change, probably from the beginning of September 2025, and wills are going digital, since the registry for unpublished wills is coming. The registry will be managed by the Notaries Association, and all wills, handwritten, secret, and public, will be published without revealing their content, respecting all the necessary guarantees of secrecy. Private wills will be deposited at a notary by the testator himself and not through a third party. The notary will enter and post the will on an online platform, and at the date of death of the testator, the platform will provide the appropriate code to open the file and allow the notary to publish the will. These changes intend to simplify the process and increase security in terms of drafting, filing, and publishing wills, as well as introducing a new institution that will facilitate the administration of the estate for as long as the testator is still alive. However, we should not forget the legal actions that can be taken during life, such as parental provision under Article 1509 of the Civil Code, and the establishment of a gift, donation, during life to any third party for any real estate or an undivided share thereof, located within the Greek territory in full ownership, part ownership, or in usufruct. A parental provision is a contract between a parent and a child whereby the parent gives his or her property to the child free of charge in order to support the child's family, financial or professional life while the child is still alive. What we need to have in mind is that there are legitimate options for the transfer of inheritance. The appropriate legal assistance will guide us to choose the one that suits us most.